With any kind of legal planning, there are documents, as you would imagine. Lawyers love documents. We love them. For an estate planning attorney like me, documents are my bread and butter. And the reason that documents are important is because they lay out your wishes. They formalize your plans so that they can be implemented when you're not able to implement them yourself, either by reason of incapacity or if you're passed away at that point. With properly prepared estate documents, you can rest assured that your wishes will be carried out as intended, and that someone else's plan won't take over yours and control what happens with your family and your asset, which is critical. And I think everybody is looking for that. What are these essential documents? We've previously talked about what estate planning is on other episodes, and just as a refresher, estate planning is the process of organizing and arranging your assets and affairs to ensure that they're distributed according to your wishes. It involves more than just writing a will, and it encompasses various legal documents, which is excellent for today's topic, so that you can protect your assets and your loved ones.
You are listening to the Legacy Talk podcast hosted by James A. Jones,
attorney at law and founder of Sound Legacy Law, PLLC in Tacoma.
Attorney Jones is here to talk about how to best protect your family, assets, and wealth, pulling stories from his more than 20 years of helping families and business owners protect their assets, create their estate plans, preserve their wealth, and plan for the future. Nobody wants to think about estate planning, but life has a way of sneaking up on you, and at any moment, something unexpected could happen that will leave you regretting not having acted sooner. So join Attorney James A. Jones in the Legacy Talk podcast, and together learn how to plan for your future today and have peace of mind tomorrow.
Hi, welcome to Legacy Talk podcast. I'm your host, James Jones. I'm an estate planning and probate attorney in Tacoma, Washington. I've been practicing law about 20 years, and my practice includes estate planning, probate, and estate administration. On this podcast, Legacy Talk, we talk about topics that surround families and estates. Estate planning is often a confusing and complicated topic, but my goal with this podcast is to make it understandable and accessible to everyone, and especially those who need it. So if this is something that interests you, I'd appreciate it if you clicked on the subscribe button and like this episode so you can follow along, and we can together break down the barriers of estate planning. I'm excited to get to today's topic. Today we're talking about the essential paperwork, the key documents that you'll need for your estate plan, so that you'll know what documents you need to protect your family and assets and your legacy. So today, on today's show, we're talking about essential paperwork for estate planning. The title of this episode, Essential Paperwork, the key documents that you need for your estate plan. So let's get to it. With any kind of legal planning, there are documents, as you would imagine. Lawyers love documents. We love them. For an estate planning attorney like me, documents are my bread and butter. And the reason that documents are important is because they lay out your wishes. They formalize your plans so that they can be implemented when you're not able to implement them yourself, either by reason of incapacity or if you're passed away at that point. With properly prepared estate documents, you can rest assured that your wishes will be carried out as intended, and that someone else's plan won't take over yours and control what happens with your family and your asset, which is critical. And I think everybody is looking for that. So, what are these essential documents? We've previously talked about what estate planning is on other episodes. And just as a refresher, estate planning is the process of organizing and arranging your assets and affairs to ensure that they're distributed according to your wishes. It involves more than just writing a will, and it encompasses various legal documents, which is excellent for today's topic, so that you can protect your assets and your loved ones. I'm going to talk about 5 main documents today, plus I'm going to add on a few others that are helpful as well. So the first document that is an essential document that I'm sure that everybody that's listening to this or watching this podcast has heard of is a last will and testament. Who would have thought? A last will and testament basically is a document that outlines how your assets will be distributed upon your death. In this last will and testament, you as the testator or testatrix, which is always kind of a fun word, you name an executor or a personal representative to carry out your wishes and manage your estate. A will also, for young families, provides a guardianship provision, so minor children can be taken care of by the people that you want to take care of them. And they also, in minor kid situations, often provide a trust to manage the assets of minors because they can't have stuff in their own name, as most of you know. A will can also contain burial instructions, funeral instructions. That's not as commonly put into a will, but it is something that you can list in there. And then it also includes contingency plans. So what happens if someone predeceases you or if you pass away at the same time as somebody else? It also has those contingency beneficiaries who would take in a situation where a primary beneficiary wasn't available to take those funds anymore. So a will's essential. A will, everybody's going to need a will in one way or another. The second document that's an essential document is a revocable living trust. Many of us have heard of a living trust or a revocable trust or a inter vivos trust. The trust essentially is a will replacement. Okay. It does this very similar job as a will in that it lays out a plan for distribution of your asset. It nominates and names someone to manage those assets and plan, called a trustee instead of a personal representative or an executor. The difference between the trust and the will is significant, though. The revocable trust is a document that lives with you. You're the grantor setting it up, you're the trustee managing it, and you're also the beneficiary. So your stuff stays your stuff and stays in your control. The great thing about the trust is the benefits it has during lifetime and when you pass. Okay. So with a trust, you often avoid probate, which is basically a court proceeding to administer someone's estate when they're passed away, court supervising an estate. And that's almost always required in a will situation when there's only a will. With a trust, it's almost never required, which saves time and money is the bottom line. It just saves complexity. It keeps things private, which is one of the other benefits of the trust. The trust doesn't get filed with the court because there's no probate. And so the nosy neighbor next door doesn't come and check on your assets and see who's getting what and what there was. The other thing that's good about the trust is that it doesn't just affect you when you pass away. It affects you and can help you during your lifetime. If you ever become incapacitated, the trust provides that the successor trustee, who's that executor, personal representative person that we're talking about in a will, in a trust during your lifetime, that person can help manage your affairs, manage the assets that are in the trust, which in most cases are the majority of your assets. And so that's a huge benefit to avoid things like a guardianship or a conservatorship, which we'll talk about a little bit later. And then it's just easier as far as dealing with the trust. There's a smooth transition of assets between the trust and the beneficiaries, much smoother than having to go through a will and a court process to administer that will. So trusts are great. I like trusts in planning. So that's the second document. So the third essential document on my list is a durable power of attorney. And so a durable power of attorney is a document that you sign during your lifetime, of course, that appoints an agent to help manage your financial affairs. And that person is designated that if you're not able to manage your affairs, they can pay your bills and write checks and deal with banks, and all those kinds of things so that your affairs remain intact if you're not able to manage them yourself. But durable power of attorney for finance in this situation is limited to finance. But you can specify the exact nature that you want to allow your agent to have, basically, with regard to managing your estate. And so you don't have to worry about things that you don't want to have happen won't happen, as long as you don't designate those things in a durable power of attorney situation. And the great thing about a durable power of attorney for financial decisions is that helps avoid a conservatorship type of proceeding, where a court gets involved to help manage someone's financial affairs, which is a disaster, in my opinion. If you can prevent it, I always recommend that my clients avoid a conservatorship or guardianship. And then the power of attorney, durable power of attorney, is revocable. You can always change your mind. And it's durable. Durable means that it is effective even if you're incapacitated. So if you're not able to make decisions, which is the primary reason you have one, that document will survive and last and allow someone to help manage those affairs for you. Now, the next document is a healthcare power of attorney. And these documents can be separate or they can be joint. A lot of the time I'll do them as a one single joint document for financial and medical affairs. And the reason why is then you don't have to carry around two documents to all your appointments and to doctor's offices and all that stuff. And so that's typically how I do it. But oftentimes someone wants a different person to act with regard to their financial affairs versus their healthcare decisions. And so that's why we would separate those two out between financial and healthcare. With a healthcare, obviously, that's pretty self-explanatory. It allows someone to manage your health care decisions, dealing with doctors and hospitals and authorizing treatment and withholding treatment, making sure that your wishes in that regard are taken care of, okay? We want to make sure that these things are done and in place in case something bad happens, right? The healthcare power of attorney avoids something called a guardianship, which is a court proceeding to appoint someone to help with your personal affairs, your medical affairs primarily, which is also linked to a conservatorship, which we just talked about, which also is typically a disaster if you have to do it. I wouldn't recommend it. The healthcare power of attorney also provides that your agent can access your medical records, overcoming HIPAA restrictions, which are very prominent these days, and making sure that your wishes are carried out in that regard. It works in hand with healthcare directives, which we'll talk about next, which is our segue to the next document, which is the living will or healthcare directive. You hear this document called a living will, and many of you have probably heard of these lawsuits that have been going on over years and years. There was one when I was a brand new lawyer involving a woman named Terry Schiavo in Florida, and there was a major issue because she didn't have a healthcare directive. So around that same time, I had a lot of calls for clients to get those in order because it was in the news prominently. But a healthcare directive or a living will basically states your preferences with regard to medical care, such as life support, sometimes organ donation, and it provides treatment choices about whether you want to have nutrition and hydration, certain medications, and things like that. The biggest thing about a healthcare directive or living will is that it really relieves your family from having to make those decisions or having to guess as to what those are. The healthcare directive in Washington is basically a summary of what your wishes are with regard to your end of life care. And that allows your family to know where you stood as far as, did you want to have life support removed or did you want to leave it on? Did you want to have nutrition, a means of obtaining nutrition remain in place, or hydration remain in place if other life support's removed? So that stuff is all taken care of in that healthcare directive. And it complements the power of attorney documents, where in the healthcare durable power of attorney, that document allows the agent that you appoint in most cases to remove and withhold medical care. Okay. And so they can take you off life support at that point with that document. But with the healthcare directive in hand, they know that that's your wish or not. So they work alongside each other in that regard. And also, if you've ever been to the doctor or hospital or getting surgery or anything, they always want you to have those, right? They want you to, do you have a healthcare directive? Do you have a power of attorney for medical? So all those things are things that you're going to need one way or another. And the reason why is they work and they allow people to make decisions if you're not able to in critical moments. So those are the primary documents. So every estate plan that I do has a will, a power of attorney, a healthcare directive, okay? And sometimes a healthcare power of attorney and a financial power of attorney, depending on what the client wants. So certain plans, though, in Washington state, we're a community property state. So there's some bonus documents here I'd like to talk about. First of which is called a community property agreement. And the community property agreement is basically an agreement between a married couple. And that agreement basically allows a married couple to decide and agree that all of their assets are community property, which essentially is joint property between a husband and wife. And designate that when the first spouse passes away, that the assets that are community property between the marital community pass immediately to the surviving spouse. So what that means is if there's a house or a car or a bank account or things like that, the community property agreement can cause those assets and title in those assets to immediately vest in the surviving spouse without having to go through a probate process or formal estate administration process, which makes it much easier for a married couple, particularly married couples that don't have significant assets, don't need tax planning, to make sure that they can at least avoid one probate when the first spouse passes away. So that's the first of these supplemental documents or bonus documents. So if you come to see me typically, and you're a married couple and you do a will plan, typically I'll recommend a community property agreement to simplify things a little bit at least. The next thing you want to consider as far as a bonus designation, this isn't necessarily a document per se, but it's something that you want to do to make sure that certain accounts are distributed properly, okay? And so that's beneficiary designations. So you typically think like life insurance policies have beneficiary designations. You can put a beneficiary on bank accounts. And the most commonly used is the retirement account, most likely, like an IRA or a 401k. Those accounts pass typically only through beneficiary designations. And the reason why is complex per se, but essentially it's you don't want to pay taxes during your life that you don't have to pay by taking those funds out of retirement plans when you don't need to yet. And so when you're creating a trust, we typically don't have people transfer their retirement plan assets into the trust during their lifetime. We do it through beneficiary designation later. And so those beneficiary designations essentially say what's going to happen with those documents. If they go to your spouse or your kids or friends or charity. And you can also name contingent beneficiaries on those too. And it gives you flexibility because with a beneficiary designation, it's pretty simple to change those. It doesn't require a formal legal document typically. It's just a form usually filled out with the entity that holds the account, the institution that holds that account. And so that's a critical part of an estate plan and something that I always talk to with my clients, making sure your beneficiaries are the way you want them. The next thing that's important and sometimes overlooked, I often get the question, how do I instruct people about certain things that are personal to me, like how I want my kids raised, or how I want to be treated at my funeral, or what songs they want to be sung, right? Or who they want to speak. And typically that kind of stuff is not in a will. Typically, it can be, but it's typically not. So I recommend typically to do a document called a letter of instruction. And it's basically a letter offering informal guidance with regard to things like raising kids. What church do they go to? What schools do they go to? How do you want them raised philosophically? Typically, all that stuff is kind of thought about pre-drafting and pre-designating these guardians and stuff. But just to reiterate and make people have a peace of mind they're looking for, I often recommend writing a letter like that. It's not a legally binding document, but it does help clarify wishes, and people that you trust enough to give your kids to or to put in charge of your estate or your assets for administration purposes are typically reliable and have enough connection to you that they would honor those wishes. The other thing that those letters can contain is information with regard to your bank accounts and digital assets. And you can also leave personal messages in those accounts to individuals that you wouldn't necessarily think would be appropriate in a will setting to leave a personal note. And so that's typically where I recommend to put information like that for the family and executors and special wishes. Finally, the other document, or this isn't necessarily a document, but it's something to consider in our day and age, where we all have a Google account or a Facebook account or Twitter or Instagram or X, I guess it's Twitter now. But where do we have all of our stuff digitally? What are those details with regard to our online banking accounts and websites? Excuse me. I think that, most people do online banking these days. Many of us have investment accounts that we manage on our phones. We have social media accounts all over the place. And a lot of those companies like Google and Facebook and Meta and X and those social media type companies, Apple, they have strict regulations that they are on their side with regard to whether they share that information or let others access it. And so, if you want to make sure that your executor or your trustee or estate administrator, that's all the same thing essentially, has access and knowledge of those things, it's a good idea to create like a digital asset inventory. That can be done on different levels. It can be done on a simple piece of paper. It can be put in a encrypted file. But it just helps manage those digital assets, especially these days when so many people have these online accounts that many don't think about when they're doing their estate plan. So that's important to include. Now, I've got a story. I wanted to share something about what happens a lot in my practice. I've been practicing about 20 years, and something that happens a lot, this scenario, is waiting too long to get these documents in place, right? Particularly with regard to durable powers of attorney. Okay. So that's really what I wanted to focus on in this story segment, but which basically is, here's the scenario. Okay. A son or daughter comes into my office for a consultation about their parent. Mom or dad is having health issues and they need help at this point managing their affairs. Sometimes this has been a long process and they've been fighting with mom or dad with regard to trying to get some control and help them. Like, Mom, let me help you. Dad, let me help you. And oftentimes it's to the point where their parent is incapacitated to the point that they couldn't sign additional documents. They don't have the legal capacity, whether it's due to dementia or other health issues, to sign. So they come to see me or attorneys like me. And in these situations where there's no planning done, there's no power of attorney, Or the alternative is there's either no power of attorney done or anything else done in that case, or they've done a do-it-yourself style power of attorney. And that, the kind that you get online, like free power of attorney for Washington or whatever, or you buy it at the Staples or Office Max or whatever, Office Depot. You can buy those sheets. And those forms aren't technically state specific, really. And they often don't have what they really need. And so certain provisions, I guess what I'm getting to, certain provisions are required in Washington state to be included in a durable power of attorney if you want to be able to do certain things, like amend estate documents or transfer assets for qualifying for long-term care. And so oftentimes, if they have this limited power of attorney, or which is a bad way to say it, but a power of attorney that's limited in its scope or incomplete in its scope, then they have problems doing things like transferring assets or effectively planning for long-term care, or even talking to a doctor, right, or a hospital. And so if that's the situation, oftentimes the solution is to do a guardianship or conservatorship. Like I mentioned it initially in this podcast, a guardianship is like a court case that allows someone to be appointed guardian over someone that's incapacitated. Okay. And there's reporting requirements and oversight, and it's a long process, and it's a complicated process, and it's an expensive process in most cases. And it takes away every right, basically, that your mom or dad or uncle or brother have. Okay. So that this guardian that's appointed can make those decisions. And a conservatorship is the same thing, only over their assets. So guardianship covers medical and personal and physical style decisions, whereas a conservatorship deals with financial matters, paying bills, managing accounts, and other assets. And those have strict reporting requirements and lots of different hoops to jump through. And so that simple, I need to get a power of attorney for mom, or what do I do for dad now, is often too late, and often turns into something much more complicated than the client wants. And so that's kind of what I'm talking about today is, the essential documents, these critical documents, the last will and testament, the revocable living trust, the durable power of attorney for finance and for healthcare, the healthcare directive. Those are essential, right? We've got to have those in order to have an effective plan. And so it's good to know. And one of the reasons for this podcast is to educate and get these types of ideas flowing so that we make it easier to understand and contemplate. Estate planning is not that complicated when you're working with a professional, and it's something that shouldn't be delayed. And then the other documents are things to consider: the community property agreement, the beneficiary designations, the letter of intent as to managing kids and stuff like that. And then dealing with your digital assets. I've done more than my fair share of special motions in a probate setting, which is a court setting to administer an estate. We'll talk about that another time in more detail. But oftentimes these companies like Google or Apple or Facebook or Yahoo or whatever require these specific motions and orders. Even though an executor is appointed by the court to manage assets, they want a special designation or a special order just saying that they can talk to Google or access a Google account or access an Apple account. And so having those logins and passwords and locations in the first place is nowadays essential as well. And so, I'm thankful that we've got this sort of opportunity now to handle our estates and talk to professionals. And so if this is something that you'd be interested in, please like and subscribe to this podcast, and keep listening to Legacy Talk for more information like this, because many of these issues that we deal with today, with long-term care, managing incapacity, what happens when mom or dad dies, or if I die and my kids are young, all of these issues can be dealt with through an effective estate plan. And that's what I'm here to help people learn about and make progress on, because that's why we're here. We're here to grow, to learn, to continue to progress, make sure that our legacies are protected, our assets are protected, and our families protected. So I think that's it for today. Thanks for listening to this podcast, Legacy Talk. If you like today's episode, please click that like button. If you like this kind of topic, please subscribe for more info and more content like this. And I thank you for listening. And until next time, this has been James Jones with the Legacy Talk podcast. Thank you.
Thank you for listening to the Legacy Talk podcast by attorney James A. Jones. If you found today's episode helpful, we ask that you like and follow us on all major platforms so you don't miss out on the latest episode. If you have questions for Attorney Jones, reach out at info@joneslegacylaw.com or visit our website at joneslegacylaw.com. Join us again next week for another episode of the Legacy Talk podcast.